Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to share today's conversation with Kevin Morrison with you. In a time when many lawyers settle cases, Kevin and the partners at his firm Altair are known for trying them. Altair cases comprise 2 out of the 4 finalists for Trial Lawyer of the Year trials this year. One of those was a case Kevin tried with fellow Altair partner Josh White to a stunning verdict in Santa Clara County, a place not known for handing out large verdicts. Kevin also led the prosecution and trial for one of the higher profile cases in recent Bay Area memory, when Allied Universal Security allowed an armed individual into a UPS facility in San Francisco, where the individual used a MAC-10 to kill 3 and injure 2 before killing himself. Outside the courtroom, Kevin is a talented swimmer and cyclist. He's leveraged his cycling skills, passion, and knowledge to advocate for fellow cyclists. Please sit back and enjoy this conversation with Kevin. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts, and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on this show. Have a guest suggestion? Email us at podcast@coopers.law. Welcome to the show, Kevin.
Thanks, Miles.
I want to start, as I frequently do, with a little bit of background information and kind of getting a sense as to what brought you to the law in the first place.
I was always interested as a child in the law. I was a bit of a ham as a child, and I thought I liked the performance, or was intrigued by the potential of the performance part of it. I also liked advocating. Wasn't much of an arguer so much, but I liked advocating for folks. And, some of the legal shows when I was growing up, LA Law or some of the other legal shows looked pretty interesting to me. I was intrigued with the idea of being a trial attorney, advocating for folks, and being able to make a comfortable living. All kind of made sense to me from a fairly young age.
Do you have lawyers in your family, in your background?
None whatsoever. Nope. My dad was a middle-level manager at Xerox. I grew up in Western New York, outside of Rochester, New York. My mom was a homemaker. My grandfather worked on the assembly line, GM, putting carburetors together. My grandmother was a maid. So no lawyers.
And I ask this question because there are a lot of lawyers that I've come across where if not their parents, sometimes also their grandparents came out of the law. And it seems like sometimes those individuals almost have an osmosis-like understanding of what's going on around them. Have you found that it has been any sort of a hindrance in terms of your getting into the law, in terms of you being the first?
No, I don't. I think you need to do what you're interested in doing. You should pursue wherever passion takes you is what you should pursue. That's what I tell my kids. My kids have zero interest in going into the law, at least so far, and that's fine with me. So it's probably going to be a one and done lawyer for the Morrison family for at least a few generations here. But I just think you need to love what you do and then pursue that.
As far as law school is concerned, did you go to law school out on the West Coast?
No, I started law school on the East Coast, Albany Law School in Albany, New York. Spent the first 2 years there, and then due to a significant personal situation that arose, I spent my 3rd year at USF School of Law as a visiting student. So I started in New York and ended up in San Francisco and never went back.
Is there something about the West Coast that you liked better than the East Coast?
Pretty much everything. I got off, I was a kid in Western New York, very middle class, not big travelers. My mom didn't fly. And so I had never been to California. I got off the plane, San Francisco, and I'll never forget the first time I saw San Francisco. It was basically the top of Twin Peaks as you drive down Portola there with that magnificent view of the downtown San Francisco, which ironically is my daily commute if I choose to work. I'll never forget seeing the city and it took my breath away. And it was love at first sight, and I'm still in love with the city. It's just a magnificent place, physically beautiful. I love the weather. I love the neighborhoods. I love the hills. I love the diversity of the people, the restaurants. You're 3.5 hours from Tahoe, a couple hours from Monterey Bay. You got the ocean. It's just a incredibly blessed place to live. So, yeah.
What made you select USF? If you hadn't been to California ever before, how did you end up out here?
So I'll give you the brief personal story. I was adopted at birth. I was born in the mid 60s, and sealed records were the thing then. Nobody knew who the birth parents were. So I was raised by a great family outside of Rochester, New York. My parents initially could not conceive, so they adopted me. I was adopted right at birth, and then they had my sister 2 years later. And so I was raised knowing I was adopted, but not knowing anything else about that. Went to college, and then went to law school. In my first year of law school, I got a phone call asking me if, is your name this? Is your birth date this? And were you adopted? And I answered all those questions, yes, but hesitantly, of course. And it turned out that my birth parents had hired a quote investigator to kind of track me down. And so that their story was they were 15 and 16 when they conceived me in Western New York. Again, the mid 60s, there were no options. Mom found out daughter was pregnant. You're going to the home, you're giving birth, and you're coming back and going to high school, 2 days after you give birth. And that was it. Wow. They ultimately stayed together. They got married. They moved to the West Coast. They had 2 other sons, and they wanted to know their oldest son. They kind of wanted to introduce the brothers. So that's how I ended up out here. So they had moved after they were raised in Western New York as well, and they moved to the West Coast when they were in their 20s in San Francisco. And so that's how I got to San Francisco. That's quite a story. It is. Are you still in contact with them? I am. That's really neat that with the sealed records, that you were able to reconnect like that. Incredible gift. Yeah. I never thought it would happen, and certainly never, it was not on my menu. Oh, they probably got married and had kids. I just, I thought it was probably a mistake, a bad time in their life. And that was it, kind of chalk it up to that, and never really considered that this would be a possibility. So, yeah. And here I was going to follow up with the St. Thomas More Society, wondering if that had anything to do with your selection of a Jesuit law school. It does not, although interestingly, I chose the Catholic faith actually, and I've been involved with a church for about 15 years or so. But it had absolutely nothing. Complete coincidence. And for those who are not familiar with the St. Thomas More Society, could you tell us what that is? Yeah, it's the Catholic group for lawyers, and they've got a San Francisco chapter. And they have the big thing they do is the Red Mass in October, where they'll invite they'll give an award to someone and have a speaker. Usually, it's a retired judge or sitting judge or prominent lawyer, and then they'll have a dinner after. But they'll have some talks depending on how active the president is. It's been in and out of activity certainly since the pandemic. It's kind of hit a inactive part, but hopefully it'll get a little more active soon. And you mentioned being involved with the Catholic faith, and for the last 15 years, was that something that drew you to a Jesuit school at all, or was that something that just kind of flowed naturally? Flowed naturally. Yeah, my selection of USF, I went to USF because I got in, and it was in San Francisco. Those are the 2 things why I went to USF Law for my 3rd year. Yeah. Once you finished law school, where did you find yourself? So in 1992, when I graduated, the economy was not great. And I was in law school one day at property class, and a professor said, "Hey, anybody want a job in Walnut Creek?" I'm like, "Yeah, I'll take a job." And it was with a workers' comp defense firm. And there was 1 or 2 lawyers that did subrogation. And so my first job was a subrogation attorney, where I would represent the workers' compensation insurance companies in third-party lawsuits trying to get their money back. And that's what I did for the first year and a half of my career, which was a great way to get exposed to the personal injury area, which I loved. And pretty soon, though, I knew I wanted to be a plaintiff's attorney. I didn't want to work for insurance companies. I certainly didn't want to represent the lien holder. So that was my first job. When you're doing that kind of work, subrogation work, I presume you're finding yourself in cases where you're seeing what I would expect to be a wide range, but probably some pretty good plaintiffs' lawyers as well as some pretty good defense lawyers. Is that what opened your eyes to the idea that you might want to be a plaintiffs' lawyer? Absolutely. Yeah, you do get exposed, like you said, to some top lawyers and some not so top lawyers. There's some car crashes in there, but I was exposed to a lawyer named Stanley Bell and his colleague Bob Arns, and I met them and got along with them. They were Stan had a prominent plaintiff's practice. He was with the Picardo firm, who was kind of the father of all plaintiffs attorneys in the Bay Area. It seems like there's a lot of folks who've worked for Picardo or variations of Picardo over the years. And so Stan and Bob took a liking to me, and we met, and ultimately they ended up hiring me in 1994. And so I've been doing plaintiff's work since then.
Did you first meet them in your role as a subrogation lawyer?
Yep, exactly. Yeah.
What iteration of firm was that when you were with Stan and Bob Arns?
So the law office of Stanley Bell was a spinoff of Picardo. Stan Bell was a partner of Picardo. Stan started his own law firm in 1979 or 1980, I believe. And so the law offices of Stanley J. Bell was formed in about 1980. And that's the firm I went to work for.
Okay. I want to stay there, but just so I kind of follow the family tree, so to speak. At what point did you end up? Jones Clifford was not Stanley Bell's firm.
Correct. Never. Nope.
So how did you end up there from Stanley Bell's firm?
Yep. So I went to Jones Clifford in 2002. It was called the Law Office of Stanley J. Bell for a reason, because it was his firm and it was going to stay that way. And there were some talks for a while about bringing on partners, and it became clear that that was not going to happen. And so in 2002, I made the decision to leave, and I went to Jones Clifford.
Your comment about Picardo being the grandfather or so of firms for plaintiffs' lawyers were split off the same family tree. Bill being a Picardo lawyer as well. So
he was indeed. And Stan, I remember Stan told stories about Bill. Bill, I believe, was the workers' comp lawyer at Stan or Picardo's office. I'm not sure if Bill was there. I think Bill was there pre-79. So that would have been in the Picardo firm. And Bill's told me the same story too. So yeah, they worked at the same firm for a period of time. Yep.
So what kind of cases, rather than make presumptions that these are third-party workers' comp overlap cases, what kinds of cases did you work on at the law office of Stanley J. Bell?
Bread and butter were ironworker cases. So he had a lot of connections with ironworker unions and other construction unions. So the bread and butter Stan Bell case was a construction site injury case, much like the Veen firm, as I'm sure your experience. So, ironworker, falls off a building, there's inadequate fall protection, rebar exposure, things like that. That would probably be half to 2/3 of the cases were construction site cases. And then after that, anything from scuba diving, accident, plane crash occasionally, some car crashes, some truck crashes, almost anything. Occasional med mal, although I think I've only done one or two of those. Stan his theory was you pretty much sign every case up for the most part, because if you do a good job in that case, then their nephew or their uncle or their neighbor will get hurt and they'll call you anyway. And so he was quite... he would sign a lot of cases up.
How large a firm was it at that time?
When I joined, there were 12 to 14 attorneys, 3 full-time investigators, employed investigators on a different floor. So it was a pretty, decent size for plaintiffs firm. It was a pretty big operation.
I'm going to fast forward to present day. Does your firm have any full-time investigators?
It does not.
What did 3 full-time investigators do for the Bell firm?
When there was a construction site injury case, we would know about it pretty quickly through the union connections. They would often get to the job site, document the scene with photographs or interviews, statements. Sometimes they would take tape recorders and take statements from folks and take pictures. And so they were often involved with getting to the scene of incidents quickly thereafter, documenting it. And if not, they would meet with witnesses, and gather evidence, and you'd have every file that you'd get had an investigation file, green folder, investigation, and they were often quite, this is pre-electronic file era, quite thick, a lot of information there, a lot of statements, and they did a good job.
One of the areas that I had some questions on in kind of that early era of practice, when you had large construction site incidents like this, was the management of evidence, because in this era, everything is digital PDF, documented up the wazoo. How did you as a young lawyer deal with gathering the evidence for something like a complex multi-employer worksite?
It was excruciating. You would find yourself in a lot of job site construction trailers on these document production where, let's say you sued, it doesn't matter, Webcore Construction or some big contractor. And so often they would, in their document production, say, okay, come on over to the trailer and we've got 12 boxes for you. Have at it, kid. And so you'd go to the construction trailer where it was usually quite warm, probably on purpose, who knows? And you'd go through these boxes and they didn't appear to be any sort of file system that was organized in any way. Again, maybe on purpose, maybe not, I don't know. And you'd literally go through the boxes and the papers and put a Post-it on something you wanted copied and et cetera. That's literally what you would do.
That seems exhausting.
It was exhausting. It builds character, I would say. It also, it gives you an eye as to, sometimes you kind of learn things by just kind of looking around the trailer. You shouldn't probably let us in there sometimes. Not that we do anything untoward, of course, but sometimes someone would say something that inadvertently that might lead to something, or there'd be a poster that could help your case that you could take a picture of or make a note of, and so sometimes you learn some things that could help you out too.
Going back to the structure for the firm, with I think you said 12 to 14 lawyers at that time, were they built into trial teams in any fashion? Did you shadow somebody? How did you end up learning the ropes from talented lawyers like those?
Yeah, so I was hired in 94, and Stan had decided that he wanted to get 2 associates to work with 4 attorneys. So one associate would be assigned to 2 attorneys. The other associate would be hired to 2 other attorneys. And so I was hired to work for Tom Caselli and Steve Bell, Stan's son. And so I started working for those 2. And for the first year and a half-ish I was there, I worked closely with Tom a lot and Steve a little bit less, but similarly, which was incredible mentoring experience. Literally just sit in their office, listen to phone calls, sit through depositions with them, attend client meetings with them, attend depositions with them, basically watch them work. Of course, I go to like case management conferences and start taking depositions, but it was incredible. It was a wealth, a luxury of mentoring. And that's where, I came into contact with Tom Caselli. I don't know if you want me to go there now.
Please.
Okay. Yeah. So Tom was, I consider him the single greatest mentor I've ever had in my life. He's an incredible human being. He was, when I met him, he was 42-ish. Started his career as a defense lawyer at Jack Williams' office in San Jose and got hired by Stan's office sometime in the early to mid 80s, I believe. And Tom was just bigger than life. He had an incredible personality, just a force of nature. He would make friends with pretty much everybody. The first time I met him, the first day of work, we walked down to his office and there were some window washers that appeared behind his desk. And because his office had some sliding glass doors, he could actually open and start talking to the window washers. And so this is the first day, within a half an hour of meeting him, he got to know the window washers by name, got them coffee, just connected with people. That's who Tom was. He was extremely personable. If you didn't like Tom, you probably had an issue yourself. So he was just wickedly personable, massive charisma, and just a great way to learn how to litigate and try cases, but not having the other side be your enemy. And it was fantastic. And he was hilarious and self-deprecating and just very funny. Sadly, he was diagnosed with glioblastoma and died 8 months later at age 44 and left 2 young kids behind and a wife. So it was rough. And I still think of him almost every day. And it was a great opportunity, though.
Did you have an opportunity to try a case with him?
No. When he passed, I not only inherited his fantastic corner office, I also inherited his caseload, and there were some dogs in there. And the first case I tried was one of Tom's cases. It wasn't even a fender bender; it was a rear end crash with no damage. And that was my first trial, though, and it was Tom's case, and it was just kind of nice that my first trial I considered it his case, and so. But no, I unfortunately never had an opportunity to try a case with him.
And I'll ask about that case specifically, but any of the other cases that you tried at that office, how was it staffed? Was it just you going out to try that? Did you have a paralegal? Did you have a partner that you went with? Fill in the blank.
No, no paralegals, no partners, no nothing. So that case was, that was just me and a bunch of boxes, and you wheel over to Contra Costa and you call your experts on the payphone and hope that they're there. And it's just all me. And that's how I tried my first 5-ish cases, all by myself. Occasionally I'd have an investigator who would help corral witnesses. So if I'm in a hotel room in Fairfield and I need the crane operator or somebody to come in the next day, I would have the investigator make sure that he got there. But no paralegal, no associate, nobody. Just me and myself and whatever wits I had about me. That's how I did my first 5 or 6 cases. So, which is great, terrifying, but the experience that I gained it's just invaluable.
And I know that's a ways back, and I know for modern era lawyers, just the idea of doing something by yourself like that seems kind of surprising.
Mm-hmm.
From those first 4 or 5 cases, are there any pieces, whether it's something from jury selection or opening or witness wrangling, anything that sticks out as this made a difference going forward in terms of how I approach things?
Treating people with respect, whether it's the witness or the defense attorney or the judge, is, treating the golden rule, treating others how you want to be treated, is what that was always a lesson that I've been taught and that I thought I practiced, but it became even more apparent when you're in trial. There's 12 folks in the community, not loving lawyers generally. We have got a terrible reputation. It's often well-deserved. And I think just treating people with humanity and kindness is something that I learned from Tom. I learned obviously from my parents, but something to execute that during trial. Jurors really appreciate that. And they've often have commented, even the first trial, but you really, tried it professionally like a gentleman. We like the fact that there was no fighting. That was in terms of just like acting like a human being and not like lawyer man is so important and something that I learned pretty early on.
What about mediation, alternative dispute resolution? And I know that that's kind of that back then was beginning, I guess would be a way of putting it. And most lawyers would resolve things either on the courtroom steps or with phone calls and martinis. Did you engage in much mediation back then?
As you said, it was kind of just starting in the mid 90s, and yes, we did do mediations. We also with Stan would often pretty much had lunch every day at a place called Tommy Toys, which closed. It was a kind of haute chinois, French Chinese restaurant across from the pyramid, basically. And so he pretty much had lunch there every day. And he would sometimes take either defense attorneys or adjusters to lunch to resolve cases. And there were no martinis, but plenty of bottles of Chardonnay. And literally, you would often settle a case on a cocktail napkin. It happened several times. You just write down the terms, and there you go. So yeah, that happened.
And was that something where you had the benefit of getting brought along to be able to kind of see how the sausage got made?
Yes, and it's incredible now. Like in today's era, people don't even take phone calls unannounced. They don't like to engage in settlement negotiations with defense attorneys face to face. They think it's kind of like they don't know how to negotiate. My way of negotiating, let's go to mediation, and that's how we'll negotiate. I think we've lost, or many of us have lost, or we're losing our ability to actually negotiate directly with the other side because they just don't want to, or nobody feels comfortable doing it anymore. It's just kind of not how it's done anymore. But I thought it was incredibly valuable to interact with opposing counsel, and you tell them about your weaknesses as well and their strengths. And there's obviously some bluffing and huffing and puffing, but generally you're sitting across the table from somebody and you're quite honest and quite direct about the strengths and weaknesses. And it was a great opportunity to see that.
I think it's worth following up on this inability to speak directly, person to person in terms of resolution without involving a sometimes pricey mediator to be able to act as shuttle diplomat. Do you have thoughts on why people have that challenge now that didn't exist, say, 30 years ago?
Yeah, it's just simply not done now. The ADR industry is so pervasive that like literally every case has to go to at least one mediation, sometimes two, sometimes three is what it seems like. And we have lost or are losing our ability to sit down with the other side and just talk turkey, talk about the case. I love ADR. ADRs are important. We settle, I'm sure, 95% of our cases, mostly through ADR. I'm not disparaging the ADR industry. A lot of great professionals in ADR, but I do think it's led to an inability for folks to talk to each other, opponents to talk to each other honestly and openly, not without giving the store away, but honestly and openly about the strengths and weaknesses of their cases. I think that's a loss.
And we'll explore this a little bit more, I think, down the road, but you're presently the president of the San Francisco chapter of the American Board of Trial Advocates. Is that correct?
That's correct.
And I know that one of the elements of ABOTA is civility and ethics. And I know from my experience that email sometimes is a little bit too rapid a way of communicating. People could be bare knuckled back in the day, but some of the civility is lost in just going back and forth on the email chain to the point where I don't want to talk to you. I don't want to have lunch with you at Tommy Toys. You're kind of an asshole.
Yep.
How do you engage with the other side? Because I'm sure you have people on the other side who are fantastic, because there are people who are fantastic, and there are people who are not. Are you a Tommy Toy settlement guy?
Yeah. Nobody, unfortunately, Tommy's is closed, but I would gladly take folks out to lunch to talk about cases, and I do occasionally. The invitation is more often than not turned down because maybe I'm just a bad lunch date, or maybe people don't feel comfortable like opening the kimono, or just, it's not even opening the kimono, it's just kind of talking directly to their counsel. I think email is so great. Like, technology is amazing in so many ways. The amount of documents and Dropbox that we can exchange with, potential clients or opposing counsel, it's incredibly, right? It's amazing. However, it has led, I believe, to a decrease in civility. It's so much easier to fire off a nasty email to somebody. It's so easy. And then, of course, that's going to elicit a similar response often. And so now we've got two folks, who knows where they're located geographically, firing off emails to each other, and they've never met face to face. And that leads to incivility. I mean, the story I like to say is if you're driving in a car and someone cuts you off, I sometimes will give a rude hand gesture or say unkind words about that person. If I'm walking on a sidewalk and somebody bumped into me, I'm not going to give that person the finger and scream at them. It just doesn't happen. Because face to face, you can't be that kind of a jerk. Email and technology allows one to be less civil, and I think that is one of the reasons why our profession is less civil than what it was. I'm not suggesting that 30 years ago was roses and everybody loved each other, or and there weren't jerks around. There were, but we generally got along with folks. There's always bad actors. There's always jerks, but it was a small community, and you knew each other, and you knew that if I was going to treat you like a jerk, I'm going to see you in another case in a year or 2, 3 years. I'm going to see you again. And what comes around goes around.
This may be a good point to ask some questions about working with Stan Bell. And the reason I ask that is because I never had the privilege of interacting with him. I am friends with somebody who was a project manager who was deposed by him. And I got a phone call from him. He was not a fan of lawyers to begin with. And I got a phone call from him afterwards saying, I just had the worst day of my life. And he felt that he had been, I would say, raked over the coals. As he described stuff, I don't think that Stan did anything out of line of what you would expect a diligent lawyer doing his job. What observations did you have in terms of various styles? It's a long lead into a style question. Various styles that you have adopted, either from Caselli or from Steve Bell or from Stan Bell or from Bob Barnes or from anyone else, as you're trying to figure out what suit fits best for me in terms of how I move my cases?
Let me start with this. You have to be yourself. And you've heard this a million times, we all have, but it's so true. Because a jury can see when you're not being yourself. You have to be you. You have to be authentic. I have stolen, borrowed techniques that from lots of folks, but that's because those techniques feel good to me and they resonate with me, and that's who I am. When Tom passed away, I tried to be him kind of for a while, and that didn't work out too well. I'm just, you can't be somebody who you are not. Can you be a human being to the janitor or the person that makes your coffee and make connections with those people? Absolutely. So I try to take that part of Tom, but I can't be as gregarious or outgoing or as hilarious as he was. So I've taken, Stan was mercurial, difficult to work with for lots of people. He screamed at people. It was, Mad Men wasn't that, I don't know if you're familiar with Mad Men, but it wasn't, that scenario was not that dissimilar from the Bell firm, even in the 90s when I was there. However, Stan was incredibly prepared. I mean, he would bring you into his office and do what's called a talk to. And he'd start, okay, let's talk about the Jones versus Smith file. Okay. I mean, these were just surprise attacks. Like, okay, come down to my office, talk to. Yeah.
And I'm interrupting a little bit, but I had heard about variants of these that seemed to come from the Picardo style, which was, if I'm putting words in Bill's mouth, I apologize, but this is my memory of the stories. And one of the stories of one of the things that Bill found unfavorable, they would bring all the attorneys around, there'd be an attorney meeting, and Picardo would grab a file and start pinning somebody to the floor publicly and humiliating them.
Yes. Stan did that in private. He did do that at some attorney meetings. He would do that sometimes. And he would do that in private. And he would cross-examine you on the facts of the file. And we're not talking about, what are his injuries, who's the doctor, what kind of wage law situation we're looking at. I mean, he would start with that, but he would go into every detail and down to the, it was almost the point where, what's the social security number? And at some point you didn't know the answer to a question. Is he left-handed or right-handed, or where do you go to second grade? And then if you missed that question, which of course you will, then he would get angry with you, and which was ridiculous, of course. But it taught you that you need to know your files. It's very important to know the facts of your case, what's going on in your case. I'm not suggesting that everything should be put to memory, but it was a good learning lesson. Like, you really need to know what's going on with your cases. That was what I learned from that.
So you have, and I wouldn't call them younger lawyers at Altair, but there are younger lawyers than you in terms of experience.
Yes.
You've also talked about some of the great mentoring you've had and some of the experiences you've had. Are there tools, for example, like being able to know the file without humiliating somebody for not knowing right-handed versus left-handed? Are there techniques that you have used to help bring the lawyers that you work with along?
Yeah, I think so. I hope so. We meet weekly on our cases and go over the important aspects of what we need to prove, what we don't need to prove, what experts do we need, what's going on with the damages, what's going on with the liability, and a lot of work around deposition prep. Depositions are trial, I feel, and you need to exquisitely prepare, especially for critical depositions, PMQs, defendants themselves. You need to exquisitely prepare for those depositions. And so we've created a model in which we make sure that before you take an important deposition, that we go over the outline and go over the important areas to cover. So yeah, that's what we do.
Depositions are trial. I'd love for you to expand on what you mean by that.
We videotape every deposition, and you can show at trial the deposition of any defendant personnel, any party to the action, including the plaintiff. But any person associated with the defendant, you can show that at trial, along with treating physicians, if you comply with the code provisions. And we've often have used to real good effect, I think, play deposition clips, video clips of defendants at trial. Most defendants are not adequately prepared for their deposition. It's just most cases settle. There's not a lot of pre-dep. It doesn't appear to me they've been very well prepped. Sometimes it's, half an hour before their deposition. Okay, tell the truth, go over this, go over that kind of thing. Here you go. And so what we have found is that you tend to get a lot of pretty good ammunition, pretty good concessions, pretty good testimony in videotape depositions. And boy, it doesn't look so good with 12 folks looking at the screen and the guy's a jerk. So that we've used those a lot.
You mentioned that you have, my word, not yours, a system or a method of preparing for deposition that your team employs. What is that method?
Making sure that all the discovery responses are thoroughly reviewed and preparing the outline based on that, based on the items you need to prove per the jury instructions or the verdict form. Making sure that all the exhibits that you want to get in through that witness you understand how they're going to get in through that person. Hopefully you can get it admitted at trial through that witness's testimony. And just making sure that you have a game plan as to how you're going to approach that witness to hopefully obtain some beneficial clips to assist your case at trial.
Fast forwarding to trial itself, because I presume with some of these witnesses, you can bring them under subpoena or a notice to appear. Are you choosing to play clips rather than have them say live?
So it depends. It depends on how good the testimony was in video. We have often simply played the videotape deposition of the defendants at trial, and sometimes in addition to that, we'll call them. So we've done it both ways.
How do you play the video depositions? And here's what I mean by that. I know that there are various trial technology programs. There are outside groups like Cogent who will show up and do a trial for you. There are firms that have their own in-house people. What approach has worked for you in terms of making sure that you've got the most foolproof way of playing these back? Because video seems to be the thing that fails most frequently in the courtroom.
Yeah. My phrase in trial is, it's always tech, because something always fails in tech and trial. Inevitably, it's going to happen. So my solution, I'm terrible at tech. I'm terrible at anything mechanical. We hire professionals. We have IT folks. I can't do that stuff. What we do, we edit the clips, obviously, and go through there and watch them, et cetera. But in terms of actually running the equipment, I'm not going to touch that stuff. I'm going to have an IT person there.
And when you say IT, are you outsourcing to a vendor, or are you doing that? Does Altair have its own people?
No, we outsource. Yeah.
And do you have a tech there then the entire trial who's helping you put on? And I ask because sometimes you have a moment where you've got the live witness, but the live witness goes sideways, so you got a nice impeachment piece that you're able to play.
You have to make sure the IT person is prepped. So when you have Miles Cooper on the stand, and there's a couple of key areas that you think you're going to impeach him on, or that are really important for your case. And if the witness says something different, he's got the IT person knows what page and line to go to pretty quickly. So look, with the discovery these days, there's not a whole bunch of surprises as to what they're probably going to say at trial. If they stray from that, you know how to impeach them. And usually there's only 2, 3, 4 different areas that are super important that you really want to impeach people on. You don't want to impeach people on, things that are tangential, right? The jury nobody likes that. But if it's key stuff, red light versus green light stuff, then you want to make sure that the tech knows page line where we're going. So you got to be quick in trial.
I was so excited to get to some of the trial pieces that I'm getting ahead of your chronology.
Okay.
So you're with the law offices of Stanley J. Bell, and then make the move to Jones Clifford.
Yep.
And I know that Steve Bell was at Jones Clifford as well.
Still is.
Did the two of you go over at the same time? How'd you end up over there?
That was kind of a funny story. So Stan, it was clear that he wasn't going to make anybody a partner. So I left in 2002. Steve left shortly thereafter and did his own thing down the peninsula for a few years. And then Steve joined Jones Clifford 2008-ish. And so we worked with someone named Ken Johnson, who retired. Steger Johnson also retired. Bill McDevitt had been there in the past. His son Andy works at Walk Up now.
Was Yale Jones there when you were?
He was initially there. He's kind of the dean of workers' comp law. I know he's very good friends with Bill Veen, and Yale was there, a very tall person. That's how I got into biking. Yale moved to Taos, New Mexico, and you need to give his bike away. And I'm about the only person who was tall enough to potentially ride it. And so I end up inheriting his bicycle.
Do you remember what the bike was?
I don't. It's funny because I inherited the bicycle and I didn't ride for a while. And then I traded it in for a bike, a Cervelle. I got a few bucks for it that I ended up, riding till as of today.
Bouncing around a little bit, but I think before we started, we were chatting a little bit about your family. And I think I recall you saying is your oldest 23?
Yes.
So you're making this move right around the same time that you're starting to have a young family, it sounds like.
Yeah. We had 3 kids in about 6 years time frame. And I was trying cases, trying to be a father. My wife was a stay-at-home mom, so she did all the heavy lifting. She raised our kids, basically. I like to think I was part of it. But I remember being in trial on Father's Day, literally in a hotel room on Father's Day. And those are the sacrifices that I made. I remember my 40th birthday. I watched, I was getting ready for trial. It was a weekend, and we went to see the movie Curious George. That kind of dates where I am, but kids wanted to see Curious George with their dad on his birthday. I went to the movie, we had pizza, I went back to work and got ready for trial. It's kind of how I was living back then.
And I know that there's no true average in terms of number of cases per year, but has there been an arc of how many trials you were doing per year at various phases? More earlier, less later, as ADR has gotten more prevalent, rapacious?
It's funny, not really. I would say, sometimes we'll do 1 or 2 in a year, and sometimes you go 3 years without trying a case. So there isn't really a pattern. In some cases, they had no idea we're going to try or didn't think we're going to try when they came in. In some cases that, oh man, this is going to try, end up resolving. So the longer I do this, it seems like the less I know, the less I can predict. No, but I wouldn't say ADR hasn't slowed down our firm's trial practice. We still take cases to trial pretty regularly, but there really isn't a pattern to it.
When your kids were young, did you have a number of, 1 per year, 3 per year?
I can't remember going 3 per year. I remember back to back once. That was rough. The kids, gosh, that was 2001. We just had one then. Yeah, I went LA and then San Francisco back to back trials. Like literally, that was very difficult. 1-ish a year, maybe 2 a year. But then a couple years, no trials.
You mentioned having your spouse was a stay-at-home mom.
Mm-hmm.
How did that allow your practice to flourish?
It was everything. She's an incredible person. When we first met, she didn't want to have kids, and that was kind of a deal breaker for me. So she saw the light, I guess, and said I agreed to have kids. So we got married and had 3. And so she was working in the finance field for a transportation company. And then the company moved to Houston. So when our oldest was less than a year old. And so she did not want to move to Houston, nor did I. And so she stopped working and raised the kids until our youngest was 14-ish, 13-ish. And then she got her teaching credential. Now she's in teaching.
Oh, wow.
Yeah.
What kind of teaching?
She teaches elementary school. So she'll now be the 8th grade homeroom teacher, and she's in charge of the math program for 7th and 8th grades at a parochial school in the city.
Oh, wow.
Yeah.
That's neat.
She's been doing that for about 6 years now. Yeah.
I guess if you're raising 3 children full time, that's got to have some skills that may be transferable.
100%. She took care of everything at home. I was very blessed. What an incredible partner. I was allowed to go to LA to try a case, or Orange County or whatever in the Bay Area. And I didn't have to do laundry or cook or take care of the kids. She did all that stuff. So it allowed me, whatever I accomplished or failed in my career, she's allowed me to do that because she was holding down the fort.
Thank you for joining us for part 1 of Kevin Morrison's interview. Please look forward to next week's part 2. Please email us at podcast@coopers.law with questions, comments, feedback on how you handle economic damages at trial, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.